Hi, welcome back to Space Thoughts. This is my first video for 2021. Happy New Year. We're almost at the end of February and almost out of winter, thankfully. What I'm going to talk about today is something that's actually been on my mind for over the past year or so, and that's the idea of the Outer Space Treaty, in particular, whether or not the Outer Space Treaty applies to private individuals or not. And this really bugs me because I think there's been a lot of misconceptions put out there as far as what this, what the nature of the Outer Space Treaty is, what the actual authority of the Outer Space Treaty is, and really what the Outer Space Treaty is in general. What does it represent as a legal instrument? So what I'm going to do today is talk to you about the Outer Space Treaty and basically try and get nuanced a little bit into this idea of self-executing treaties versus non-self-executing treaties. Now, to start this, bottom line is there is a conception out there that the Outer Space Treaty doesn't apply to private individuals. Okay, that's fine. So what's a treaty? A treaty is definitely a contract between states, and that those states basically get together and just like a business arrangement would be, they get together and they come to terms on certain matters that are mutual interest and that have international impact. Now, sometimes what they decide affect private individuals, but however, what they actually negotiate there in that treaty may not automatically flow through to private individuals under their jurisdiction, and that's especially under the U.S. form of government. So fundamentally, what I'm talking about is whether a treaty is self-executing. In other words, does the treaty automatically become force of law in the United States? And I'm going to use the United States since I live in the United States. I'm a citizen of the United States and under the jurisdiction of the United States, and an attorney under the U.S. legal system. So, or is it non-self-executing? Meaning that it has to Congress has to take an additional step in order to make it domestic law. This is going to get a little bit complicated. I'm going to try and simplify it as much as possible. But to really understand, the difference between what self-executing means and what non-self-executing means, we really have to take a look at the U.S. Constitution, and in particular, Article 6b. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land. That means a treaty that is given the advice given the the advice and consent by Congress and ratified by the President has the force of a federal statute under the U.S. Constitution. In other words, the idea is, in most cases, it's what we call self-executing. It doesn't need any more attention. However, the nature of a treaty sometimes may require Congress take additional steps, and there are certain areas where this could actually occur. So, to understand whether a treaty is self-executing or non-self-executing, we're going to go back and do way back, probably over 100 years ago, to a Supreme Court decision. Now, understand this issue of whether a treaty is self-executing or non-self-executing has been litigated to death. I mean, even recently in this century, there have been a lot of litigation over whether treaties are self-executing or non-self-executing. But I'm going to go back to what I think is a seminal decision back in 1829, and I'm paraphrasing what the rationale in here is, but whether a treaty or its individual provisions are self-executing revolves around whether it can operate by itself without the aid of any legislative provision. Okay, so before we go any further, I just want you to understand the treaty doesn't necessarily have to be completely self-executing or completely non-self-executing. A treaty could be self-executing, but have a few provisions of it that are non-self-executing. And I'm actually going to demonstrate this a little bit when we talk about the Outer Space Treaty. But what the court is saying here in Foster is that if the nature of the treaty or what the treaty is requiring of the U.S. doesn't require any further congressional action, it can become self-executing. It can become the supreme law of the land in and by itself. And I want listeners to understand that fundamentally what happens when a treaty becomes law in the United States, it basically supplants any state domestic law, in other words, individual state domestic law, but it's always inferior to the Constitution. That is, a treaty or a treaty provision can never supplant a constitutional right. And again, I'll show this to you in when we talk about the Outer Space Treaty. So understand that Constitution always is always number one. It's always on the top, and a treaty can never override the Constitution. Any provision that tries to do it will likely be ruled unconstitutional by the Supreme Court and made ineffective. So when it comes when treaty or treaty provisions are non-self-executing, there are three things three common themes that have happened in litigation over the time since Foster. Courts have found, look at the first bullet, the agreement manifests an intention that it shall not become effective as domestic law without the enactment of implementing legislation. So at the negotiation level internationally, the U.S. could say, well, look, we like this, we want to ratify this, but this is going to require some additional legislation for us in order to make it. So either this treaty or this provision of the treaty, until that legislation is enacted, it won't be binding law upon us. So in other words, it will be non-self-executing. The second bullet point, the Senate, in giving consent to a treaty or Congress by resolution, requires implementing legislation. So during the advice and consent procedure before Congress, Congress could get concerned and say to the ambassador or the representative that, you know what, we have some concerns about this particular provision. We think it might be unconstitutional on its face. Therefore, before we are going to give our advice and consent. However, we're going to after the Senate, the president ratifies it or signs it, we are going to have to pass additional legislation, and the president's going to have to sign that in law in order for this treaty or for that particular provision to become effective. And then the third bullet is implementing legislation as constitutionally required. And this is like I discussed in the first bullet. There's something just so on its face, bold-faced, that there's something that needs additional legislation needs to be had in order to make it constitutional. Else, it would become unconstitutional. And we're going to talk about this a little bit when we talk about the Outer Space Treaty some more. So just understand, those are some of the considerations. So that's a brief, really quick lesson on self-executing versus not self-executing. It's not, it isn't really straightforward. We could talk about litigation for hours here, and I don't want to bore you, and certainly I don't want to put the time into a video when we could explaining it. But understand, this is something that does exist. So let's get to the Outer Space Treaty. Now, is it self-executing or is it non-self-executing? In other words, does it need additional legislation, or is it on its face okay to become supreme law of the land? Well, there's been a lot of confusion over the past couple of years with advocates saying, well, the Outer Space Treaty isn't self-executing. In other words, it's non-self-executing, just a very generalized station. And I don't know that I agree with that, and I'm going to talk to you about why I don't agree with that. But and again, I think it's actually a combination. That it is self-executing, but it does have some non-self-executing provisions, and we'll discuss that. So I did a quick run through the Outer Space Treaty, and I basically analyzed it and figured, okay, is this a self-executing treaty? And yes, and for the most part, yes, the Outer Space Treaty is self-executing. In other words, when it was signed by President Johnson, it didn't need any additional legislation in most cases. However, there were some exceptions, but we'll talk about those exceptions in a moment. So when we get right down to it, Article 2, Article 3, Article 4, Article 5, Article 6, Article 7, Article 8, Article 9, Article 10, Article 11, those are all self-executing. In other words, those provisions don't require any additional congressional action because they really don't implicate any constitutional freedom. They really don't impact any private rights or private privileges for private individuals under the jurisdiction of the United States. So basically, when the Outer Space Treaty got signed, those went into effect. Now, how they went into effect and how they're interpreted is a different thing, and how they're put into practice is a different thing. However, they did become the supreme law of the land when they were signed in. So let's talk about a couple of the self-executing provisions. I'm just going to do a couple here. Again, I don't want to go through these one by one. It's going to get boring, and I don't want to extend this video any longer than I have to. So let's look at Article 4, and specifically I'm going to talk about the first paragraph of Article 4. State parties to the treaty undertake not to place in orbit around the Earth any objects carrying nuclear weapons or any other kinds of weapons of mass destruction, install such weapons on celestial bodies, or station such weapons in outer space in any other manner. This is the no bombs in orbit provision that was basically a big issue at the UN when the Outer Space Treaty was being negotiated. Self-explanatory. No nuclear weapons in outer space or on the moon or wherever, on Mars or wherever. It's a no-no. It's a prohibition, and it's something that, that was, like I said, very important. They even gave it the no bombs in orbit provision. So fundamentally, this is self-executing. In other words, it doesn't implicate the rights of any private citizens. Private citizens don't have jurisdiction over nuclear weapons or nuclear devices or any other weapons of mass destruction. And basically it doesn't implicate any other interests aside from the duties and obligations of the federal government. Therefore, once President Johnson signed the Outer Space Treaty, after it was given advice consent by the Senate, it basically went into force. Now, how this is interpreted is another thing, and actually I might do a video down the road about Article 4 and how some of its interpretations have come about, and maybe some loopholes, but that may be for a video down the road. Article 8 is another example of a self-executing provision in the Outer Space Treaty. A state party to the treaty on whose registry an object launched into outer space is carried shall retain jurisdiction and control over such object and over any personnel thereof while in outer space or on a celestial body. And I'm not going to go any deeper into this. You can read it for yourself. But fundamentally, this is what I call the jurisdiction clause of the Outer Space Treaty. One, it gives a state continuing jurisdiction. It basically gives the state that signs the Outer Space Treaty flag over any space object that's launched into it. When I call flag, I mean basically registration, ownership, national ownership and jurisdiction. And any personnel that go into outer space aboard those space objects also the U.S., or in this case, the U.S. retains jurisdiction over it. Again, it really doesn't implicate any rights, any constitutional rights that are afforded to private individuals under the Constitution. So really, there's nothing that Congress had to legislate on to say, well, basically we have to legislate a law saying that, repeating these words. It isn't necessary. Therefore, this is another example of why the Outer Space Treaty, for the most part, is self-executing. So I told you that, for the most part, the Outer Space Treaty is a self-executing treaty, but there are two provisions in it that are non-self-executing, and they're non-self-executing for two reasons, and for two disparate reasons. The first one is Article 1, and for this I'm going to focus on the first paragraph. The exploration and use of outer space, including the moon and other celestial bodies, shall be carried out for the benefit and in the interest of all countries, irrespective of their degree or of economic or scientific development, and shall be the province of all mankind. I'm going to focus on this paragraph, and in particular I'm going to focus on the use of outer space. When the Outer Space Treaty was being negotiated, there was concern because of these things called communication satellites. They were just starting to come into use. The U.S. passed the Communication Satellite Act back in 1962. ComSat was formed, Intelsat was formed, and these satellites were beginning to use mostly for broadcast, but also for other purposes. The concern on the part of the U.S. delegation was if another nation decided that if a government broadcast over these satellites, or a civilian broadcast over these satellites was, in their view, propaganda, it would be unacceptable. So the U.S. was concerned, okay, this is a bad thing. We have this thing in the U.S. called the First Amendment and freedom of speech. If we allow other nations to basically say that, subjectively say on their own part, for whatever purpose, whether it be political or whatnot, that a broadcast, whether it be government or civilian, is propaganda, and try to restrict that could restrict the freedom of speech under the Constitution. Well, remember how I told you a treaty or a provision of a treaty cannot supersede the Constitution or a constitutional right. In this case, the concern was Article 1, at that point when the treaty was being considered by the U.S. For ratification, the concern was that could happen. So fundamentally, what the U.S. delegation said was to the international community, to the other delegates, we want to sign. We like this treaty. We think it's important. We want to ratify it. However, we're concerned about Article 1 and how it could be interpreted. Therefore, we're going to consider this non-self-executing. In other words, during the negotiation process of the Outer Space Treaty, it was explicitly made known to the rest of the delegations that the U.S. would consider Article 1 non-self-executing. In other words, we were going to sign and ratify the Outer Space Treaty, However, we considered Article 1 non-self-executing and not legally binding until the U.S. had a chance to talk with the other the other delegates and have additional agreements about what this, basically what is acceptable for use of these things called communication satellites. And eventually that happened, and and eventually this law became legally binding, especially that use of outer space. Another example where this phrase use of outer space really kind of developed more, and it was kind of, in my opinion, made more legally binding was during the Bogota Declaration. During that, the countries along the equatorial meridian, along the equator, basically said, you know what, all of geosynchronous orbit, we own it. We own it, and people got to basically license it from us and pay us for it. Well, that was a big problem. For one thing, it was completely in violation of the Outer Space Treaty, especially Article 2. But there were it was obviously very unacceptable, and there was a big response to the Bogota Declaration. Part of the U.S. response to that was to say, okay, we don't agree with this. We don't think this is a valid interpretation of the Outer Space Treaty. Part of the interpretation also was saying, oh, by the way, this thing of use of outer space, we also consider that valid for commercial purposes. In other words, we think that commercial use of outer space is proper. So the U.S. used that opportunity to define use of outer space in Article 1 in order to, accelerate the idea of commercial space in the international sphere. Another example of how this term use of outer space in Article 1 in particular has been modified or, brought more into what we consider the law of the land is the space resources provision in the Commercial Space Launch Act of 2015. And basically what we said is private individuals can go to celestial bodies, harvest the space resources, and possess them and do whatever they want with them. And from that domestic law, the U.S. is building a case in the international arena that this is an acceptable interpretation of Article 1. So you can see by how this Article 1 has developed, this first paragraph, especially that phrase use of outer space, has developed and become binding law and interpreted as we go through time here. Again, so understand, at one point Article 1 was not a self-executing provision of the Outer Space Treaty, but it did become legally binding once we had understanding with the rest of the international community what the Article 1 really entailed. The second provision in the Outer Space Treaty that is non-self-executing is Article 6. And this is the one that has a lot of controversy here. And particularly I'm going to focus on whether such activities are carried on by governmental agencies or by non-government entities, and for assuring that national activities are carried out in conformity with the provisions set forth in the present treaty. The activities of non-governmental entities in outer space, including the moon and other celestial bodies, shall require authorization and continuing supervision by the appropriate state party to the treaty. Okay, this is where proponents of people who of those who come out and say, well, the Outer Space Treaty is not self-executing, and it has no jurisdiction over the U.S. private citizens because treaties don't apply to U.S. citizens. Okay, I don't agree with the first provision. For the first opinion, one, the Outer Space Treaty is self-executing, but it does have some non-self-executing provisions within it. Two, I agree that treaties don't apply to private citizens. However, in this case, if you go back to Article 8 that we talked about earlier, the Outer Space Treaty is a self-executing provision, and it vests the authority and the jurisdiction in the United States to oversee, one, to retain jurisdiction over space objects launched into space, but also for personnel. That was not, like I said, that was non-self-executing. That became the supreme law of the land. What this little blurb here in Article 6 does, it grants a state the right to basically say, okay, you can authorize your private citizens to perform commercial space activities. And that means, but you have to authorize them under your laws and under your regulations, and you have to continue to supervise them. Now, the neat thing about Article 6 is it doesn't tell you how to do this. It just tells you if you want to do this, this is you've got to do this. It doesn't tell you how to do it. So basically, that leaves it up to the state how to legislate it. So the idea of commercial space flight is, for one, it's not really a fundamental right in my opinion. It's really a privilege, probably implicating the freedom of free movement. But it's something that's subject to the authorization of the United States. and it's something that Congress had to legislate. In other words, in order for authorization and supervision of private individuals to actually take place, for private individuals to actually take part in these types of activities, the government had to do it, and there had to be a law. And back in 1984, the 98th, I believe it was the 98th Congress, passed the Commercial Space Launch Act of 1984, which laid the foundation for commercial space activities by private individuals. And that law has been built on over the years, and all the laws are now codified in Title 51, Chapter 509 of the U.S. Code. So Article 6 is a non-self-executing provision of the Outer Space Treaty. In other words, that provision, especially concerning private individuals, required additional congressional action because it implicated, one, in my opinion, a constitutional right, but it was also something that wasn't really fleshed out, and of course it dealt with private individuals, which treaties really can't directly affect. So in this case, it was non-self-executing, but through the Commercial Space Launch Act of 1984 and what has come out in Title 51, Chapter 509, and any succeeding legislation, the Outer Space Treaty permits these type of activities. So in a sense, it makes it the supreme law of the land. So that is kind of a quick and dirty explanation of the Outer Space Treaty, why I think it's self-executing, and really a brief discussion of self-executing versus non-self-executing. Now, as for the other four other treaties in there, Registration Convention, Liability Convention, and Rescue Agreement, those are all self-executing. There's nothing in there that Congress has to actually legislate further, in my opinion. So really, those treaties are all self-executing. But what I wanted to get out of this is, one, have a kind of a basic understanding of self-executing versus non-self-executing. Two, understand that, yeah, treaties don't apply to private individuals directly, but also that even though the Outer Space Treaty is self-executing, there are two non-self-executing provisions in there, but those have been addressed, in particular Article 6 and commercial space launch. Like I said, there's a school of thought out there right now that is saying that, well, Article 6 doesn't apply because it hasn't been enacted. I agree that it's non-self-executing, but it's already been enacted, starting with in 1984 with the Commercial Space Launch Act and what we have in Title 51, Chapter 509. So that is a brief discussion. I hope I didn't confuse you too much. It's definitely not an easy topic, and trust me, if the litigation on this is pretty deep, and I'm sure there'll be litigation on treaties in the future. Until then, I hope to do more of these videos as 2021 progresses. Spring is on its way. Be safe and be healthy.